Hi, everybody, and I'm delighted this time to have as my guest a BOTA member and defense lawyer, Alan Brubaker. Now, let me tell you a little bit about Alan. He is a leader in his firm, Wingert, Grebbing, Brubaker, and Jeske, located in San Diego, California. But he's also an experienced trial lawyer and a leader in the profession, and he's highly respected and esteemed by both peers and clients alike. Alan devotes his practice to complex civil litigation, including business and intellectual property disputes, product liability claims, and employment matters. He's tried more than 60 cases to verdict in federal and state courts, and he served as the president of the San Diego chapter of ABOTA, and admission to this is also by invitation only. So, Alan, thank you for coming today. I'm delighted to have you, and welcome to our podcast. Well, in terms of when you go to a jury trial, great trial lawyers have different opinions about this, and we'll see what the variation looks like over these interviews. But what part of the jury trial, from your perspective, is the most important and why?
I think opening statement is the most important part of most cases that I try. We've recently been invited to offer many openings to juries before the jury selection process, and that's become a really solid way in a 5-minute circumstance to introduce prospective jurors to the case. And I think we get a lot more from the jurors after providing a mini opening. Then the judge inquires, and then we get an opportunity to inquire, just to lay out what the jury ought to expect in development of the case, and to share with the jury the process a little bit, that the plaintiff's going to be presenting his or her case first, and that we'll be responding and talk a little bit about a burden of proof, obviously, once we slide into the selection process. But I think opening can be critical. If it's not done well and done effectively, it can be downhill from there.
And with the minis, about how long do you like to give a mini opening statement when the judge allows it? How long do you like them to be?
My experience is 5 minutes is outside. It really has to be focused. It really has to be controlled and well prepared and thought out. But anywhere between 3 and 5 minutes, just to introduce the jury to the big picture of the case that they'll be trying.
And that's really an important opportunity for you on the defense side and the plaintiffs on the plaintiff side, to really give them a distilled down, simple, this is what this case is about, so they start to get an understanding.
And I did one of my original mini openings in a case in Kern County involving really challenging facts, a school teacher with kids on his lap. And the plaintiff lawyer did a mini opening and told the jury that he was going to be looking for $18 million. And you could see the jaws drop on the Kern County jurors or prospective jurors' faces. And then he used a different number when he actually opened in the case after the jury was selected. It was a wild beginning to an interesting case.
When you're giving your opening statement, which you say and believe is the most important part of the trial, now that you give your full opening statement, what are you trying to do and accomplish? What's your strategy for that?
To be totally direct and candid, to take away the challenging issues from the case, to hit them up front and candidly, to deal with negatives. Always in this age to address damages, because invariably the plaintiff lawyers are addressing damages in an opening statement. That's a very different circumstance than existed when we began trying lawsuits in our careers, yours and mine. Right. Damages weren't spoken regarding, at least total numbers, until closing arguments were made. Now it's the subject of discussion in jury selection in many openings, as I shared by way of example, and certainly in our opening statements. And if we on the defense side of these cases don't directly address the damage issues raised by plaintiffs in their opening statements or in their jury selection, we can't erase what they've heard at the end of the trial.
Right.
So I think today we must and always do, even in the best of liability cases on the defense side, have to address damages in the event a jury might get to that issue at the end of a case.
And you'll do that even in the opening statement, which makes perfect sense these days.
I do, in direct response to what the plaintiff's opening statement has been. Clearly, it's in our mind's eye, from the plaintiff's side, an effort to indoctrinate the jurors to a number without any evidence existing, right, which is why we object to that, or used to object to that happening. But the plaintiff bar has succeeded in establishing that as a routine where they have to determine whether prospective jurors are simply going to eliminate the concept of significant damages in a particular case. And so routinely now, damages are spoken regarding from the very start of the case through the finish of the case, and we've got to be ready, willing, and able to address that head on and do